All right, welcome back. Bishop on Air. Another update here with the federal firearms licensees of Illinois and their challenge to the gun ban. All right, welcome back. Bishop on Air. Another update here with the federal firearms licensees of Illinois and their challenge to the gun ban registry here in the state of Illinois. In the Southern District Court with Stephen McGlynn. Of course, we heard the arguments before, and this was in the Seventh Circuit Court of Appeals with the Second Amendment challenge. But you have the plaintiffs, the federal firearms licensees, taking it back to the Southern District, asking for that January 1st deadline to be postponed while the case continues to be sorted out. Let's go ahead and pull up that docket here where you had a status hearing and Judge McGlynn set a oral arguments for this case for December 12th, and the state was given a December 1st date to respond, and they responded with a motion to dismiss. And you can see here also they've got supplemental to really kind of just add on to that motion to dismiss. And let's take a look at what we've got here. About 53 pages or so. We'll go ahead and pull this up. But as we look through this, of course, first blush, getting an idea of what exactly the state's going to be arguing here. And let's jump into it. Looks like, of course, all the different plaintiffs groups. You've got the table of contents and the arguments they make, and this gives you a really kind of overview. They say that the plaintiffs' new claims are unlikely to succeed on the merits, and those claims are that due process is at hand here with a lack of notification, proper notification for individuals who are going to be impacted by this. They say plaintiffs lack standing because they have actual notice of the endorsement affidavit process. But what is that actual notice? Have people been sent official mail about the endorsement affidavit process, or is it just putting it into the Illinois Register that, you know, tens of thousands of pages being published on a revolving basis? Is that enough notice? Maybe for certain legal eagles, but not necessarily those who are, just your typical firearms owners. The Act and its implementation regulations provide constitutionally sufficient notice for the endorsement affidavit process. They say plaintiffs' vagueness claims fail as a matter of law. They go on to say the Seventh Circuit's already held that any Second Amendment challenge to the regulation process is ultimately to succeed on the merits. Then they go on to talk about how the plaintiffs have not shown the other requirements for preliminary relief are met. And a lot of these other requirements include irreparable harm. So when you are looking for a preliminary injunction, you want to make sure that you can demonstrate that there's irreparable harm with this registration process. They say that they have not shown that some of those requirements. We'll see if they break that down a bit. But again, some of the other arguments that they lay out, in the alternative, an injunction should be limited and stayed pending appeal. So they're arguing that if Judge Stephen McGlynn does issue an injunction, because keep in mind, he did issue an injunction once before in this case on the Second Amendment issue in the Southern District, the state saying that if an injunction is granted, it should be stayed pending appeal. So they go on to break all that down with this filing Friday to the Southern District of Illinois, where we've got the hearing set for December 12th. So a lot happening on Friday, not just with this case, but also with the Calkins case and some other cases from across the country, including the case that really allows for individuals 18 to 20 years old to purchase firearms where they were prohibited from doing so on a federal basis. But let's go back to this. The injunction should be stayed if it's issued pending appeal. An injunction must be limited in its scope of the plaintiff's request, and any injunction should be stayed for the pendency of interlocutory appeal. They give their conclusion as well. So you can go and find this 53 some odd pages of the filing that the state gave to the Southern District of Illinois ahead of the December 12th dates that will all be, I'm sure, wanting to hear what happens. But clearly there's a lot of moving pieces, even with the federal firearms licensees of Illinois seeking a preliminary injunction against that January 1st deadline to register firearms. And if you guys didn't see, the Illinois State Police did update their FOID card statistics websites, which does show just how many FOID card holders have actually filed endorsement affidavits. 4,877 of the 2.4 million FOID card holders. that only comes out to 0.2%. 0.2% of Illinois firearm owners' identification card holders registering a banned item. And you're looking at nearly 9,300 firearms being disclosed, about 4,900 accessories being disclosed, and 87 ammunition being disclosed. Now, the Protect Illinois Communities Act, they have been updating the frequently asked questions, and some of the other frequently asked questions deal with like airsoft, and whether or not airsoft is something that is going to be required to be registered. If you look, is an endorsement affidavit needed for items, attachments specifically for airsoft guns. And they say here, to be an assault weapon attachment, the item must be specifically designed for a firearm. Items specifically designed for airsoft guns are not assault weapons attachments. If a person were to attach parts specifically designed for an airsoft gun to be a firearm, thereby bringing it into the definition of an assault weapon under PICA, then the firearm should be regulated. So we'll go through a lot more because they're getting ready to publish the second notice of the firearm registry regulations. So there is a lot for us to tackle here, especially with less than a month now. 3.5 weeks before the January 1st deadline to register firearms. So we've got the case in the Southern District with the Judge Stephen McGlynn going to hear the oral arguments December 12th. He says he wants to issue a decision on that before the Christmas holiday, so we'll see if that happens. But you've also got the case that was brought by Robert Beavis in the Naperville challenge in front of the U.S. Supreme Court, with the state of Illinois having to respond to that case by Wednesday. So we'll be watching that closely too. It is Bishop on Air. Appreciate you guys tuning in. Be sure to like, subscribe, hit that notification bell, and if you want to support the program, you can also check out some of the merchandise below here on the YouTube channel. All right, just search out Bishop on Air, make it happen. All right, appreciate you guys tuning in.